Term common law can refer to two things. The common law is the body of law formed through court decision, as opposed to law formed throughout statutes of writing legislation. A common law system is the system of jurisprudence that is based on the doctrine of judicial precedent, the principle under which the lower court must follow the decisions of the higher court rather than on statutory laws. In common law system, a precedent or authority is a legal case that establishes a principle or rule. This principle or rule is the used by the court or other judicial bodies, used when deciding later cases with similar issues or facts. The use of precedent provides predictability, stability, and efficiency in the law. The Latin term stare decision is the doctrine of legal precedent. The precedent on an issue is the collective body of the judiciary announcing principles that a court should consider when interpreting the law. When a precedent establishes an important legal principle or represents news or changes law on a particular issue, that precedent often known as a landmark decision. Precedent is central to legal analysis and ruling in the countries that follow common law like the United Kingdom and Canada, except Quebec. In some instances precedent is not binding but is taken in account by the court. Precedent that must be applied or followed is known a binding precedent, mandatory precedent under the doctrine of stare decisis. A lower court must honor findings of law made by higher court that is weighting the apples path of case the court hears. In the United States and federal courts, jurisdiction is often divided geographically among local trial courts, several of which fall under the territory of regional appeals courts, and all regional courts fall under Supreme Court. By decision of lower courts are not binding on each other or any court higher in the system, nor are appeals of court decisions binding on each other or local courts that fall under a different appeal court. Further, courts must follow their own proclamations of law made earlier on other cases and honor rulings made by the other court in a dispute among the parties before the pertaining to some part of the fact or event unless they have a strong reason to change these rulings.
Advantage and disadvantage of the common law. As with any system, the common law system has its advantages and disadvantages. The three main groupments in favor of such a system is that is fair, expedient, and efficient. It is seen as being fair as the strict following of precedent in all cases mean that all people are treated equally. It is expedient because basing decisions of the precedent means that potential litigants have a good idea as to what to result to expect. Finally, the existence of precedent means that the judicial process can be relatively fast as there is already a framework in place in which to base a ruling. The disadvantages include the perpetuation of bad rulings and the difficulties raised when there is no precedent for the case before the court. Once a bad decision has been made by a higher court, that decision will remain law until the same court or a higher court overrules the bad decisions. Courts are reluctant and overrule their own decisions unless absolutely necessary, and so bad decisions can upheld for a long time. That is true of bad precedents. However, a total lack of precedent can lead to many problems, especially where a court is essentially having to make new law where no previous law exists.
In a controversial 1997 book, attorney Michael Trotter blamed over-reliance by American lawyers on binding and persuasive authority rather than the merits of the case at hand as a major factor behind the escalation of legal costs during the 20th century. He argued the court should ban the citation of persuasive precedent from outside their jurisdictions with two exceptions. 1. Cases where the foreign jurisdiction law is the subject of the case, or 2. Instances where a litigant intends to ask the highest court of the jurisdiction to overturn binding precedent, and therefore needs to cite persuasive precedent to demonstrate a trend in other jurisdictions. The common law legal system originated in England, was later adopted in the United States and Canada, and is in place in most Commonwealth countries. While the English common law system has its roots in the 11th century, the present system has evolved over the past 350 years, with judges basing their decisions on those made by predecessors. Common law has no basis in statute, and is established and developed through written opinions of judges delivered at the end of a trial. These opinions are binding on all future decisions of lower courts in the same jurisdictions. However, that is not to say the common law system derives all of their laws from case law. Democratic countries that have adopted the common law system have legislative bodies at the center of the democracies, and these bodies regularly pass new legislations. This legislation is then interpreted and applied by the judiciary during trials. These rulings will then be applied in future cases under the doctrine of stare decisis, another name for judicial precedent. Large bodies of law, for example those relating to property, contracts, and torts, are traditionally part of the common law. More modern areas of law such as employment law, intellectual property law, and health and safety tend to be based on statute rather than on common law. Persuasive precedent. Precedent that is not mandatory but which is useful or relevant is known as persuasive precedent. Persuasive precedent includes cases decided by lower courts, by peer or higher courts from other geographic jurisdictions, cases made in other parallel systems, for example, military courts, and in some exceptional circumstances, cases of other nations, treaties, world judicial bodies, and others. In a case of first impression, courts often rely on persuasive precedent from courts in other jurisdictions that have previously dealt with similar issues. Persuasive precedent may become binding through the adoption of persuasive precedent by higher courts. Custom, long-held custom, which has traditionally been recognized by courts and judges, is the first kind of precedent. Custom can be so deeply entrenched in the society at large that it gains the force of law. There need never be a specific case decided on the same or similar issues in order for a court to take notice of customary or traditional precedent in its deliberation. Case law. In common law system, this type of precedent is granted more or less weight in the deliberation of a court according to a number of factors. Most important is whether the precedent is on point, that is, does it deal with the circumstances identical or very similar to the circumstances in the instant case. Second, when and where was the precedent decided? A recent decision is the same jurisdiction as in the instant case will be given great weight. Next, in deciding order will be recent precedent in jurisdiction whose laws is the same as local law. Least weight will be given to precedent that it stems for dissimilar circumstances, older cases that have since been contradicted, or cases in jurisdictions that have been dissimilar law.